Hey, this is Julie Field. It looks like Judge Kelly, who is also presenting this along with Ian Harris. Looks like Judge Kelly was having a bit of technical difficulty and got cut off. So I will go ahead and do a little song and dance until she comes back on. Thank you all for being here. What we're talking about today is leadership from the bench, cyberviolence and tech abuse in domestic violence cases. Let me ask Ian to go ahead and introduce himself, and then I will, and then hopefully by then Judge Kelly will be back online.
Wonderful. Hi, everybody. So my name is Ian Harris, and I'm the Technology Safety Legal Manager at the National Network to End Domestic Violence. I'm really happy to speak with all of you. I'm trying to look at the list here, but I'm sure I've spoken to some of you in the past. And just so you know that myself with NCJ-FCJ, so my organization, the National Network to End Domestic Violence, and NCJ-FCJ are working on building a curriculum for judges around cyberviolence and how technology is integrating itself into the courtroom. And so we're really happy to have a chance to speak with you today and to hear a little bit about your experiences, to hear from two amazing judges who are working on these issues in their own court, and to really build a group, a collection of people who are talking about these issues and thinking about how to really build out a court system that is going to be effectively able to respond to the changing needs of litigants who are dealing with the intersection of technology and domestic violence. So really happy to be here, and thank you all so much for joining us.
All right, thanks, Ian. I'm really excited to be part of this. This is, again, Julie Field, and I'm a district court judge in Fort Collins, Colorado, and have been on the bench for about 7 years doing criminal and domestic cases as well as civil. But before becoming a judge, I was a law professor at University of Michigan Law School, Washburn Law School, and University of Denver, where I dealt a lot with issues related to domestic violence and sexual assault, and have worked with the Safety Net team, National Council, and the other participants here and players here and organizers here for over 20 years, and was the director of the Confidentiality Institute that addressed issues of confidentiality and privacy and the law as it relates to victims of domestic violence and sexual assault. And Judge Kelly, are you on?
I am on, thank you, and sorry to everybody. Happy to be here with you today for this webinar. My name is Judge Carroll Kelly. I'm the administrative judge of the Domestic Violence Division in Miami-Dade County, and I've served in this capacity for 20 years. So I'm very happy to be here with all of you today, because this is such an important topic that we deal with, I think, every day in court. This webinar, I just want to start by saying thank you to the Judicial Engagement Network, the National Council of Juvenile and Family Court Judges, the Center for Court Innovation, and the National Network to End Domestic Violence. They're all wonderful organizations that have really great resources for judges. So we encourage you to visit their websites and see all of the great resources they provide to help us and to help the litigants in court. Let's just talk a little bit about the Judicial Engagement Network for those of you that aren't familiar with it. It's a national community of judicial officers who get together and meet to, really our goal is to improve responses and practices to domestic and sexual violence. We get together for peer-to-peer meetings where we have the opportunity to, number one, make friends, but also to share ideas, forms, procedures. We create judicial activities as well as judicial education, such as this webinar today. We are looking for more individuals who have a passion for these issues to join. So if you're interested, please contact either me or any of the other members of the Judicial Engagement Network. You see the website there, and you can log on and see who the current members are. It really is an amazing resource for those of us that deal with this. Because so often we feel isolated, we deal with the trauma every day and all these issues that arise, and it's really a wonderful network of people that you can call on to ask questions and sometimes just get support for the things that we see and the trauma that we face in the courts. Just so you know, all of the materials here, you don't have to download anything. I believe all the materials were sent to the participants via email, and you are able to download everything from the materials box, so there's no need to write anything down here today. So our learning objectives today are several. The first is to identify the prevalence and impact of cyberstalking and tech abuse, identify tech abuse best practices for judges, improve access to justice for cases that involve tech abuse, and examine opportunities for judicial leadership. And really, we're going to talk a lot about judicial leadership. What can we do to make the courts more tech responsive? We really want you to participate. There is a chat box. We're asking for you to please ask any questions, join in with any comments. We want this to be a conversation, so we're looking forward to this.
All right. One place to start really is at the beginning, and that is to evaluate for each of us ourselves how comfortable we are and how confident each of us is individually in our abilities to adjudicate cases that involve misuse of technology. And one of the things that we've got is a little poll here where you can answer your level of confidence. Do you not feel confident at all? Do you feel somewhat confident? Does it depend on what is the tech that's involved or being misused? Or do you feel very confident about these issues, both in terms of the technology and understanding what they are, as well as how to deal with it in your court? And are you at that level where you feel like you could train other judges on this topic? So we're going to give everyone a minute there to answer the poll, and we'll release the results here once we've had most folks participate. So we'll give you a minute to take a look at that poll. Think within yourselves of where do I fall in this range? And it's anonymous, so be honest. Okay. Anyone else want to vote? We've got a number of folks that I think are sitting on the sidelines. Anyone else want to jump in there with their feeling of confidence? No judgment here. The question of how do you send in your response, you should see a checkbox there where you can check which level you feel reflects your understanding. All right, are we ready to take a look and see where people land? Okay. I think that the answers at this point should be broadcast. And it looks like a lot of the folks land in the not feeling terribly confident or feeling somewhat confident, or it depends on what the tech is that is being used. So it looks like there's some additional information that might be helpful to folks to parse out these issues. Thinking about that, and we'll give you some information about some of the things that I hope will help you to become a little bit more confident today and give you some other resources. But let's think about what are the most prominent technology issues that you face in your court. What are some things that come up frequently, whether that is in a domestic case, a criminal case? What are you facing in your court? And go ahead and answer in the chat box so that we can get a sense of that. A few minutes, a couple minutes to do that. Think about the prevalence of technology and the use of technology by everyone really in our society. It's not surprising that some of the answers that we're seeing here in regard to what people are experiencing in court are things like someone who's texting or calling at all hours of the day or night, doing that kind of harassing or even stalking type of behavior. Social media and how social media might be used and abused by folks. Texts on cell phones and pictures. How do you, as a judicial officer, get that information and apply that information, get that information into evidence, and particularly around those self-represented litigants. Alleged hacking of email and spoofing of phone calls is a big challenge as well that folks are faced with. Harassment through mass emails to all contacts. That can happen in social media as well, where there's disparaging and lying about the victim, the person who is being targeted. So it seems like there's a lot of challenges that people are seeing in court, where it's dealing a lot with social media, with that daily interaction that people have around technology, whether it's through their phones, through their computers, social media, the photos that are so prevalent, including some that may be sexually explicit, and concerns about privacy and confidentiality. So there's a lot of use of technology and the potential and a lot of abuse of technology that I know we as judicial officers are seeing. And I'd like to give Ian an opportunity to really talk about that from the abuse perspective and from the perspective of the folks that are experiencing this. And then we can jump into the what do we as judicial officers need to look for, and how can we apply our skills that we already have as judges to understand and evaluate this evidence. So, Ian?
Thanks, Julie. I appreciate it, the feedback, and then also thank you all for those who are typing information into the chat box. It's really useful, and I just want to say that we just did a large-scale needs assessment across the country and spoke to a lot of judges about what issues were most relevant, what issues were popping up for them in court around technology and domestic violence. And a lot of what we got feedback on was very, very similar to what I'm seeing here, and it was sort of a mix of a variety of different types of technology that are being used and misused in court, and that there were some pretty challenging evidentiary issues that were arising, and those evidentiary issues were in some ways exacerbated or worsened by the limitations of the court. And those limitations in some cases were that there wasn't sufficient technology to actually, accept certain types of digital evidence. There was some issues that seem to have been noted above in the chat feature, that people may not be able to actually project the images of different types of digital evidence, that there might be concerns about having to take phones, that people, particularly self-represented litigants, were ill-prepared to come to court to provide information about tech abuse and the evidence that's related to it. And then I did note in the chat box, and I hope that you all saw it, I thought this was a really great point that Janet brought up about the use of basically using calls that are court mandated, where children, need to have communication, or I'm guessing that might also have something to do with court mandated conversations around pickup and drop off and children's welfare, and how those can be misused, how those calls can be misused. So really great points, and I think you all hit a lot of them. I just wanted to take a couple of minutes, because really what we want to look at today is to delve into the great amounts of resources and wealth of information that Carroll and Julie have, and that all of you have. So that's really going to be the beef of this. But I did want to go really quickly through some findings and what we see regularly regarding tech abuse. So in terms of technology, I think it's important to acknowledge, and I'm sure that people are coming from all over the country, so I'm sure that you all recognize that different courts have extremely vast differences in terms of what access to information and what access to resources their jurisdiction might have. Similarly, that different populations within our society have, very different access to certain types of technology. There's oftentimes it's referred to as the digital divide. That digital divide has historically been in reference to access to, high-speed internet, but that has sort of changed. I mean, what we know statistically speaking, that there are certain communities that have much lower access to computers, to internet, but are increasingly having access to other types of technology, particularly technology like mobile devices. And so what has been interesting in our society is that as much as there is not a balance and equality, whether it's because of rural issues, because of poverty issues, not everybody has the same access to technology, but there is an expansion, and in some ways mobile devices are bridging some of that gap. And so what we're tending to see is that most technologies that are commonly used and commonly accessible are moving towards mobile platforms. And so mobile platforms, meaning smartphones, tend to be the technology, at least from what we're hearing around the country, that's most relevant to the most number of people around the country. And so we really focus a lot on the issues of mobile devices. But mobile devices and the technologies that people are accessing and using through that are certainly not all that's out there. There's a lot of other technologies that are pretty commonly used. Everything from GPS systems to hidden cameras. Just as a little anecdote, these things like hidden cameras used to be something that actually the late 90s, early 2000s, people were really terrified of nannies, and there were these things called nanny cams, which were these very large teddy bears that had VHS tapes in them. They were pretty intense. But nowadays, hidden cameras can be very, very small. A couple of, I think at the latter part of last year, I had a case, and in that case, the victim, the survivor, came to me and was concerned that there was surveillance happening in the house. And what we actually were later able to uncover is that there were very small little flash drives, so drives where you store information, thumb drive, flash drive, where the perpetrator in that case actually had purchased these thumb drives that had cameras in them and was putting them in multiple places throughout the house. And with these cameras was able to record for a certain period of time, a few hours, and then take it and watch the recordings on those cameras or taken from those cameras, which is really frightening. And when we looked online for how much these things cost, they were about $19. So we're talking about very, very cheap things. And to be honest, that's pretty rudimentary. That's pretty low on the low end of the technology spectrum as it stands at this point. So technology is really moving forward, and of course there are lots of ways that technology can be misused, and oftentimes is. But the things that I think are most relevant for most people is around mobile devices, so that's what we're going to focus on. Now, I do want to note that it's easy to think about technology as being the problem, and it really isn't. You know, what we hear from individuals who've experienced the misuse of technology is that realistically, it's the same things that, you know, the same type of abusive behavior that was happening without technology. It now just has a tech component to it. So technology is really the tool. It's not so much the abuse unto itself. You know, almost any way that we can think about how technology is misused, we can think of a way that there is an analog version of that oftentimes has been used against people for a very, very long time. The difference is that technology has the capacity to make that abuse faster, more easily replicated, and potentially, you know, more impactful because it is easier to send around. But at the same time, technology also is absolutely a requisite for obtaining safety, whether it's about finding shelters or moving to a new home or checking on your children and maintaining, you know, parental responsibilities. Technology is so integral to how people think, and it's not like just because someone is experiencing abusive behavior that we can necessarily say that people have to get rid of all of their technology. It's not a reality. It really is not a reality for people. And then additionally, and sort of the last point is that technology actually also has a lot of safety components to it as well, and we are regularly communicating with individuals to think about how technology can be leveraged to help increase safety, and how, you know, I could give you lots of examples of times where, you know, technology actually really was protective over someone's physical safety. I have at least one case in which technology and the use of technology actually saved my client's life without, you know, sort of beyond a shadow of the doubt, it saved my client's life. So it's not enough to just think about the ways that technology is misused. We also have to think about the ways that technology can be protective. So as time has progressed, technology has become more and more integrated into the way people communicate, the way people interact, in good times and certainly in bad. We went around the country and asked domestic violence programs how many were seeing the misuse of technology regularly in their cases, and 97% of the programs, this was years ago, came back and said that these were issues. At this point, you know, not only do I think that number is indefinitely 100%, but I think the number and the percentages are so high. I mean, within the last probably 5 years, there's very few cases that I have had when representing people in family courts that have not had some sort of tech component. The only real question has been whether I asked sufficient questions to elicit how technology was involved. And I still think that we have a long way to go in that department. So I think technology is almost always there, whether it's evidence that gives some sort of context to the abusive behavior, or that technology itself is being misused in a way that continues to perpetrate the violence. Whichever side of it is, there's almost always a technological component. And, you know, I have found that I oftentimes, it's my questioning or my lack of questioning or failure to ask the appropriate questions that really determine whether or not that issue of technology is brought to the forefront, but whether or not it is, it generally is there, just because that's how people interact nowadays. So how are we seeing tech being misused in domestic violence cases? So the obvious examples pop up, right? Stalking, surveillance, harassment, impersonation to some extent, destruction of reputation. I think something that doesn't pop up a lot in family court, except for maybe in the child support context, is around fraud and theft, but that's actually very, very common as well. So it's, I got into the practice with my clients to actually run free credit reports for clients, with the client, almost with all of my new clients, truthfully. I would take them through the process and have them run those credit reports, because what I was finding is that time and time again, my clients would discover that through that process that there was, the abusive party had opened a credit card in their name, or had said that they were paying a bill but had failed to do so, and now they had a fair amount of consumer debt that they didn't actually realize that they had, that there was actually this fraud and theft component to it, because it's so easy to sign on to and to create accounts online, had led to mass amounts of fraud. And the reality is that most of the individuals who are experiencing violence and dealing with the crises that come with that violence oftentimes didn't have, they weren't able to focus on things like their credit scores, because that just wasn't the top of their list. But once they discovered that this was impacting them, it became very, very important, because it's very hard to get a new place to live if you're actually escaping violence if your credit score has been completely ruined. Other examples of destruction of reputation, of course, it could be anything from non-consensual disclosures of intimate images, so that's oftentimes referred to as revenge porn, or to just send messages, emails, calls, text messages to employers, to friends, to family. It's a pretty normalized part of how abuse actually functions nowadays, but oftentimes parts that don't make their way into court because it's not the way that questions are asked of individual litigants. The harassment, I think, is better. Surveillance, to some extent, though it's quite difficult to prove, and so a lot of times people are leaving that information out. But I do want to note that the stalking behavior is something that is quite, correlated with extreme violence, including fatality issues, but oftentimes is left out of petitions because people have a very, very hard time proving it, and because people are concerned that to say that they thought somebody is spying on them and listening to them and potentially reviewing what they're sending online might make them sound not legitimate in the context of the court.
Yeah, and Ian, if I can just add in here, I think also, in the area of revenge porn and sextortion cases where somebody's threatening to release intimate photos unless somebody pays them or does something else for them, many victims feel shamed coming to court. And I think sometimes it's the response of the court itself. So if we as judicial officers have a response of, well, why did you take those photos, that's further shaming the victim. And there's really nothing wrong with two adults engaging in consensual sex and sharing in an intimate relationship. But when that gets turned around to the harassment and threats, then it turns to we have to turn to the abuser and not shame the victim. And I think that happens a lot of times. So many victims are embarrassed to come to court and admit that they took these photos. But again, going back to the point that there's nothing wrong with that. Where the harm and the wrong comes in is for the people that abuse that trust, that confidentiality, and use it to control and to destroy a victim.
Thank you so much for that, Carol. It's a really important point. And I actually, just to give an example from my own experience about how I was serving as a major barrier to finding this out because of the shame that you just referenced, I found that for my clients, I was finding that about 1 in every 30 of them were expressing that they had these images that they were concerned about somebody distributing, or images that had already been distributed. And in doing that, I wanted to note that what I basically did is I changed the way that I asked about it. I asked them very specifically when I was first meeting them. Actually, before I even took their cases, I would say, look, I see that in this order of protection that there is specific language that precludes, somebody from coming to your home and for communicating to you. And then I noted that I had other clients who had other issues that had not been dealt with within those general boilerplate provisions, particularly noting that maybe it's a sister's house that the person spent a lot of time with. And then I specifically said that I have clients who, had images that they were concerned might be sent around, images or videos. And when I said that, when I brought it up and when I said it without trying to shame anybody, what I found is it went from about 1 in 30 people to about 30%, or about 1/3 of the people who came to me had some sort of image that they were concerned about, which is actually much more consistent with what we know about statistics of these sorts of images. And so it really was about me and how I was asking that question that was really important. We don't have time to get too much into all of this, but what I do want to say is the way that we're starting to think about technology in domestic violence cases is into these 4 categories: direct communication, social media, images, and surveillance and privacy. And the reason we've grouped them in those ways is because basically the evidence oftentimes looks very similar in those categories. But these are also the things that we're seeing pop up very consistently in the majority of the cases, with texting and social media posting being the things that around the country people said were the biggest issues for them. So a couple of quick things, and then we're going to move forward. But I just want to say that there are a number of evidentiary issues that pop up. We're seeing major issues with the collection of digital evidence to begin with, that many self-represented litigants in particular are ill-prepared and don't know how to do it, although I'm also hearing that many attorneys are struggling with this. That there are issues of whether or not this particular evidence is the best evidence, because oftentimes digital evidence is being transferred from a digital format like a mobile device and being transferred to physical. There are, of course, authentication issues, reliability issues that have been brought up and have been concerns, particularly around the issue of spoofing. That hearsay issues are there as well, and some concern because the person communicating may or may not actually be in court, and it might be hard to actually link that person. And then that generally that there's large systemic barriers that have popped up, whether it's about access to information about how to collect this information and store it and present it, to whether or not questions about digital evidence are even being included, and whether or not there are laws that are there on the books that will help to be used. I do want to invite Carroll or Julie if you have anything to add to this. If not, then we can keep moving.
Well, I just want to add in that, just the recognition that in so many cases the electronic evidence is essential to establish a material issue. And so the way that we as judicial officers deal with these issues can create profound consequences on the outcome of the case.
I would agree. And not just the outcome of the case, but the willingness of someone to come forward and try to introduce evidence of this type. For example, just going back for a moment to the sexual photographs, ask yourself if, as a judicial officer, you actually have to see the photos, or if you can accept the testimony of someone that those are out there and that they are being distributed. So just to add that additional level of what do I really need in terms of evidence and testimony and information to be able to make good decisions about this. And we do this every day as judges. We deal with evidence, we deal with credibility, we deal with authenticity issues every day. This may be an area and types of evidence that we're a little less familiar with or a little less comfortable with, but it's the same skill set. And I want to remind you of that it is your same skill set as judicial officers that you use every day. So keep that in mind as you're analyzing this.
Julie, that's such an amazing point. And, one of the questions that has come up pretty regularly, just to express what I'm hearing from people, is that there are some serious concerns that the judgment from the court around somebody having had nude images taken or that they maybe took themselves really does keep people from bringing some of these issues up. And there's a particular concern about what will happen when that information is introduced into evidence or is put into the court file. I can particularly tell you that when I have practiced and I've gone into a records room to see files and to look through it, I oftentimes will see that there's, a manila envelope that says don't open, but has no other protection, and that, in that envelope is protected information that I have complete access to. And so, not only thinking about what you as the judge need to see, but also knowing that your courthouse and the safety behind the mechanisms in the courthouse can really impact whether or not someone's going to be willing to bring this information forward and whether or not that protection is going to be available. And so going with that, I'd like us to move forward and ask, Carroll, first, are there ways that you are working to increase your court's capacity to handle some of the tech abuse issues that I just referred to? Are there things that you're doing that you can suggest for people?
Well, I think one of the most important things is like what we're doing today is for people to be educated. So oftentimes people just don't know enough about technology. I know as judicial officers we're precluded from using certain types of technology, or it's strongly discouraged, or for safety or other reasons we don't engage with that. So having the opportunity to learn about it and use it, I think, is a big thing for us. Become familiar with it so that it's not scary for us. So training and judicial training on this, I think, is key. I also think, though, for the people coming into court, more and more self-represented litigants, and according to the poll that you showed, almost everybody coming in has some form of tech evidence that they want to present. But we run into the hurdles of individuals not knowing how to do it. And like some of the individuals said on the chat box, in some courtrooms, phones aren't even allowed to be brought in. So litigants don't know how to bring this evidence in. And it is really tricky. And so I think educating the public. Here at our court, we've posted online for the public different informational videos. We have some of the material we're going to share with people later today, guides for self-represented litigants on how to introduce evidence. And I think things of that nature, really it's education not only for the judges but for the public, and most particularly for the self-represented litigants, because we want them to have their day in court. We want the courts to be used for the peaceful resolution of disputes. And so anything we can do to help people have their day in court and provide justice, procedural and otherwise, it's a win-win for everybody.
Great, thanks. Julie, anything that you want to add to that?
Yeah, I think one of the things, and it goes back a bit to the point that you were raising earlier, Ian, about what might be contained in the physical file, is that this is not just an issue of judges getting the information or learning how to be more proficient with this themselves, but to really go all the way down the line in terms of the clerk's office, even the security personnel in your courthouse, the folks that are in the self-represented litigant assistance office, if you have one of those, and making sure that everybody in your courthouse is aware of these issues if they deal with folks that may be victimized by it.
And I also think there's a great comment on the chat box about continuing a case to allow a victim to come back with the evidence. So that's a really great point from Michael, that, yeah, we have to provide the opportunity for people to present their evidence. And if they come and they don't have it in the right format, not ruling on their case, but giving them the opportunity to bring back the evidence that they want to present in the format that we need to accept it in.
I would agree.
Yeah. It is a good point, and I know that there are a lot of judges who are dealing with tremendous pressure to keep cases moving along, and that that can be a challenging one. Though I think it is ultimately worth it. Though I will note that the jurisdictions where there are more robust self-represented litigant information in advance, I do think that that really increases the likelihood that you're not going to have to adjourn that case, that you get the evidence that you want. And, I recognize that there's a resource limitation there, but I do think that you're starting to see things pop up around the country where there are more and more resources available. And we'll also talk about some of those things that might be available today, but that really is going to get the information that is going to be necessary for good decision making. So thank you very much. Julie, I think this one's for you. Can you talk a little bit, both of you, referred to the importance of education and communication, but have there been things that have really helped you to increase your knowledge about tech abuse and have made you better equipped to deal with the issue when it arises in court?
Yeah, and I'll start, but I'd like other folks to jump in on the chat box as well, because there was a range of responses when we did the poll. So there's some folks that I think have gotten a little bit more information themselves, and so I'd like to see what their resources are as well. As I mentioned in my introduction, I've worked a lot with SafetyNet from the beginning of that project with the national network, and so I've learned a lot from folks like Ian and Cindy Southworth and Erica, just in terms of getting all of that kind of knowledge base from almost the inception. And I commend them to you as a great resource for that basic tech information. But what has helped me to increase my knowledge of tech abuse, I think, is first taking a look at this is abuse, and it is the next step in the evolution of abuse, and it is very pervasive and something that we have to be aware of and work on. But finding out about, like Ian was saying, making sure that you're asking the right questions. So taking that information from SafetyNet, getting information, just familiarizing myself with technology. And at least here in Colorado, we've got pretty darn good resources in terms of our technology within the court. And I have in my jurisdiction, I'm lucky enough to have very eager tech people who work with the courts who will sit down with me, and when I say, I don't understand this and how this works, who will sit down with me and help me understand at least the basics in terms of the technology. That doesn't get to the abuse issue, but it does help me understand the technology and how that can work and how it is intended to be used and how it could potentially be misused. So Carroll and Ian, I don't know if you have any other thoughts, or it looks like there might be some thoughts in the chat box as well. The ICAC task force members to offer educational training to court staff, that's an excellent resource. Mark indicates that he will use anticipate electronic evidence and help to direct pro se litigants in particular. I think that's fantastic. And making sure, again, that the security staff know that that might be coming in. I think that's excellent.
Mark, I really appreciate that point, and I think this is Ian, that it gives a great kind of holistic view of the courthouse, thinking there are of course going to be steps and necessary steps in order to provide protection, but that in order to get the best possible in front of you, it means thinking about all of the people that a person is gonna interface with before they get into your courtroom, and that's really sounds like a really wonderful way to respond to that issue. Carroll, anything to add?
Well, I've also learned from the litigants. So litigants may come in and have certain technology or platforms that I'm not familiar with, and I'll just ask them, explain to me, and it's basically learning every day.
there are nonstop. There are so many different types of technology that are changing all the time. It would be impossible to know everything, but I did want to note, and I think your point, Carol, is a good one, that we all have people in our lives who may have different areas of expertise, and it's really great to make those connections in a way that we can continue to grow and learn, because honestly, it's totally necessary in the context of technology to continue to learn and grow, because it's always changing. Thank you both for your thoughts. And again, we encourage people to provide other examples in the chat box. We will do our best to read them out if at all possible. So Carol, going back to you, what steps can courts take to create a more tech-responsive court, a courthouse, or a court system? What steps have you all taken, and what do you think other courts might be able to do that maybe you have been able to do, or that you would like to do and haven't been able to do thus far?
Well, I think one way is to be a little bit less rigid and inflexible, and understand that people are going to be bringing this evidence in and helping to facilitate receiving it. So, for example, if a litigant comes in, as they often do, with just their cell phone, and on that cell phone there may be text or emails or photos, and they didn't bring a copy, and they're not seeking a continuance, I can get past that by just simply asking the bailiff to show the other side, giving the other side to make an objection, which rarely happens, and then reading what I'm looking at on the record and telling both sides, if anybody objects to my characterization of this, please, speak up. And that way the record can contain the technological evidence, and we can, get through the hearing, and it will be on the record. So that's just one way of just being less rigid, I think. I think we want to create an environment in the courtroom where people can share their experiences and their victimization from technology, and create an environment where they're not afraid to share it, where they think they're not being taken seriously, that this isn't serious abuse, because this type of abuse has lifelong impact. Anybody that's ever had their identity stolen knows how difficult it is to get beyond that. And also to just, not be told by the court, well, just don't use technology, don't use Facebook, don't use Instagram. I think we need to really, and what we've done here is try to educate everybody on how important technology is. As you said in the beginning, it's a lifesaver. It's a means by which people stay in contact, remain safe, get jobs. So the understanding that we can be flexible and try to help self-represented litigants who are coming with this type of evidence and have their day in court.
Great, thanks, Carol. Julie, anything that you want to add to that? Any other suggestions?
Nothing that I don't think has already been said, except just going back to Carol's first point about the reading the texts that are on the cell phone. Some judges might say, well, that's not the best evidence. And in fact, the best evidence rule is the best available evidence. And so having that actual phone there and being able to read that, I think, unless there's some kind of an objection that it's been altered or modified in some way, is indeed the best evidence. So don't let those technical pieces of evidence rules interfere with your analysis as a judicial officer of evidence that you take in every day.
Another thing I just wanted to add, Ian, and that's a great point, Julie, is that when we enter final orders, and I'm talking specifically if you're in a hearing for a restraining order or an injunction, simply entering an order that prohibits somebody from having further contact once this type of tech abuse has occurred doesn't really cure the issue. So I think crafting orders that address the harm that's been inflicted, for example, if somebody's posted revenge porn photos and has those photos, an order that directs them to immediately erase all photos from all devices, from the cloud, from all storage devices, and to contact where they've been posted and immediately have them taken down, with then sending in an affidavit to the court or proof to the court or scheduling a compliance hearing to ensure that's been done. That type of action, is really fundamentally important for these types of cases, because it's not good enough in these cases to just say, don't contact the victim anymore. We need to take some affirmative steps to cure the harm that's already been done.
It's a really great point, and building out tech responsive dispositions and really identifying what the potential harm there is so important, because what I do see is that when there is a potential harm that is not dealt with, that oftentimes is brought up in some context and the orders don't reflect that, then I think that really has the potential to undermine the likelihood that someone's going to comply with the appropriate order, because they feel like that issue has arisen and there hasn't actually been a clear structure about what is appropriate and what's inappropriate in terms of contact. And so that's a really, really great point. I did want to note that for some other people around, other judges around the country have talked about both making sure that there was options in their courthouse for individuals to get access to literature. We're going to give one example about how to present evidence. We've heard about courts around the country who have basically found ways to have Bluetooth-enabled printing options so that people, if providing a phone to read it into the record or some other device isn't sufficient, so that they can print out the materials. The truth is that nowadays, with everything moving towards a digital platform, it can be incredibly difficult to get access to a printer in some communities, and quite expensive to boot. So having options around that can be really useful as well. We've talked to jurisdictions that have had really strong conversations with the front line before somebody gets into court. So that's officers that are checking people in, that's clerks, that's a number of people who are going to be interfacing with individuals before that they come in court, to really give them the information, not to tell them what they have to do, but to make sure that the person is prepared when they get to you, can be really, really helpful. I'm seeing a couple of comments popping up, and I just did want to note those. That there may be times where you will see potential issues around electronic evidence coming up within the petitions, but that there might be some opportunities, some situations in which that information is lost. I will just, on that note, around the country, what we hear about how people in petition rooms tend to ask about what somebody should include in an order of protection, they'll oftentimes say, what was the first, the worst, and the last incident. So many people, when they hear that, even if the technological component is actually a very big problem for them, they may not give that information over because they think it would be a non-responsive answer to the first, worst, and last. And so the questions that are asked within the courthouse can be a really, really good idea to think through as well. I did see.
I just wanted to add one thing in here. I'm sorry, Ian. Go ahead.
Yep. No, please.
So Janet asked the question: if we ask the perpetrator to take it down, how would this be followed up on, and what consequences? So the way we follow it up here is either by having the perpetrator submit an affidavit that it's been taken down, and quite honestly, the victims check this. I mean, they're on it because they know about it and they're checking it. So if they fail to do it, what we do is it's either a violation of a court order that can be punished by contempt, or depending on your jurisdiction, violation of the injunction would be a new crime. So they can be charged criminally if they fail to do it.
Thank you both. So moving back to Julie, what resources do you think would help courts to respond better to tech abuse? What resources do you think are useful?
I think we've talked about a number of them already in terms of making sure that judges are taking leadership on this, that they have the information available, that they're sharing it. We've talked a fair amount about evidence, and I think really digging in and understanding that would be another help, and working with judges like Judge Kelly and myself and some others in the Judicial network to get that kind of support in terms of creating this across your courthouse. But I also think developing and sharing orders that can be, that have been successful in cases, I think would be an extraordinary resource for judicial officers to make sure that they've got that. And I expect there's going to be some talk a little bit later at the end of the seminar about what kinds of resources MCJ, FCJ, and Safety Net and BAWA have in regard to this project. But that, I think, it's one thing to bring the evidence in. It's another thing, like some of the chat box questions we're discussing. Okay, what do you do if you find that there is this abuse and you want to stop it?
Right. So maybe I'm going to expand this out to either of you, and then also for those who are participating, would love to hear in the chat box. But we have talked about a number of resources. For those who are responding in the chat box, are there any other resources either for self-represented litigants or for the court generally that you think are really important to include? If so, we'd love for you to put that information in the chat box. And Carol, I didn't give you a chance if there's anything you wanted to add.
Well, no, but I think under our materials box, which I know we're going to speak about, the two publications, How to Gather Technology Abuse Evidence for Court, the Self-Represented Litigant series, as well as the 10 Steps for Presenting Evidence in Court. Anybody that's on the line can download that and get it put on your court website. We've printed copies and put it down in the intake centers and have them in courtrooms for people. So I think sharing these, because these are two amazing, amazing publications that help self-represented litigants understand the steps that they need to take, what the court might need, and to be prepared when they come in. So posting that on court websites is amazing, and also giving the links to in the intake centers around the courthouse. Here's places that you can go to, research and be ready for your day in court.
Great, thanks for that. We do hope this How to Gather Technology Abuse Evidence for Court, we just completed it pretty recently, and so it is pretty up to date, and I think you all will find that it has a lot of really good information that will help people walk through the process in a pretty hands-on way in getting that evidence and that information. Similarly, the second, moving forward, around presenting evidence, they're both pretty thorough and thoughtful examinations of how to do this. I did want to let you all know that on our website, so the National Network to End Domestic Violence, we have a website called techsafety.org. And on techsafety.org, there is a variety of content specifically for individuals who have experienced this abusive behavior, everything from how to document evidence to how to identify misuse to begin with. We have some information about for agencies specifically, and we have a variety of content that's going up for both attorneys both in the criminal context and in the civil context, but we also have a variety of content that through our work with NCJ, FCJ will be coming out in the next year or so specifically for judges to help, to evaluate, identify, deal with issues revolving around tech evidence. And so what I will include is, I appreciate the thoughts that people are expressing about what are some of the resources that they're using, but if there are particular resources that you have not seen that you think would be useful for you in your court system, please take a moment and let us know in that chat box, because we would love to do our best to build those resources for you. We have some money to make that happen, so please let us know if there's something that you want us to build for you, and we're happy to do our best to make that happen. So I think let's keep moving. I would like to present this both to either Carroll or Julie, whoever wants to take it first and foremost. But do you think that there are laws, policies, or procedures that would help courts to better respond to tech abuse? Now, just noting that there is a huge spectrum of availability of different types of legal responses around the country, and that there are many different jurisdictions, but do you think that there are things that would help from a law or policy or procedure standpoint? Nobody wants to take it.
Yeah, I'll take it. So I really do think that many of our laws, I think across the country, there's laws about stalking and cyberstalking, but they don't fully comprehend the issues and the impact. And so, I think legislatures and leaders are in the same boat as we all are, that this is an ever-changing area and it's hard to stay on top of technology. But I think California has some great laws specifically regarding cyber stalking and remedies. I think they're really the leader in the field. They provide for restitution and in the orders themselves that California has, they have provisions to take down the material. And I think if we had laws here in Florida that were that specific and that tailored to really the needs of the survivors, it'd go a long way. That being said, I think so many of us across the country have the opportunity within our laws to craft orders that provide relief under sections such as provide other relief necessary. And I think most jurisdictions have laws that provide for that. And we've seen some of the different participants today share with us ways that they have written in their orders things to allow victims to come into the courtroom and to craft relief under that term. So for sure, I think we need to keep educating our legislatures about this and to tighten up and to expand the relief necessary for victims.
I would agree with that, and I think that as we are all aware that the legislation generally lags behind the technology really on all levels, but particularly in the civil and domestic context, I think we do have quite a wide swath of discretion as judicial officers to do things that are going to protect people in civil protection order context and protect kids and other parents in the domestic relations context. So there may not be criminal penalties for sharing consensual photos, non-consensual sharing of consensual photos, but there can be some consequences and limitations around that in the best interest of children, in the protection of victims. So I think there are some things that we can do as judicial officers, even though the legislature may not have yet caught up. And I like the idea of looking at what have other jurisdictions done in terms of their statutes, their protections specifically. And maybe we need to think in each of our jurisdictions about taking a hard look at what those laws are. currently in your location, and is there anything else within the rules of evidence that maybe needs to be expanded as well?
And
one thing, I'm sorry, go ahead.
Yeah, really quickly, Carol. I just wanted to note that with the point about the importance of seeing what other jurisdictions are doing, now I know people here are not necessarily legislators, but if you want to know what some of the laws are around the country, we have a project called womenslaw.org, and under women's law we have a whole slew of legal options from around the country that look at what tech focused legal responses exist in all 50 states that might be useful to people. So that's womenslaw.org in case folks want to look at it. And then Carol, I'm sorry to interrupt you.
No problem. So actually in preparing for this webinar, I was looking at the different California laws, which really are great. And one thing we're doing here is I've been asked to be on a group that looks at our forms for our different types of restraining orders or injunctions. And I was looking at our stalking injunction, and I thought, well, we could really improve this stalking injunction to include checkoff boxes for many of the cyber crimes and cyber harassment issues that we face, to make it far easier for victims coming in and filling out these forms. And so that's one thing we're going to be doing here, and that's thanks to, just researching and becoming aware of some other jurisdictions that have already, started on this project and expanding on their good work.
Thanks, Carol. And I did want to say that, the reality around the country, when you really start digging into the laws, Julie brought up that there's a little bit of tension between the criminal court option and the family court option, and I do think that there is some flexibility in the family court that doesn't necessarily exist, or at least in the civil context that doesn't necessarily exist in the criminal court context. But the reality is around responses to technology, the criminal court has been in the forefront to a large extent, but there are some serious limitations in relying exclusively on that. And so creative thinking about how to respond in the civil context, both because there are a number of people who don't wish to go through the criminal court process, and two, because there's a number of jurisdictions, and when I say a number, I really am talking about a very large number of jurisdictions who have taken positions in the criminal law enforcement context that make it very, very hard to get the necessary support with tech-related issues. So there are jurisdictions who essentially refuse to do forensic evaluations on devices, so digital forensics, unless there is a felony issue. And so all the other misdemeanors, of which the vast majority of the cases fall within that, really aren't going to be even investigated in a real way. And so, for some people, maybe the criminal court is not the way that they want to go about it. But for many people, even if they wanted to go in that direction, it would literally be an impossibility for them. And so it's really important to think how another court system, might be more effective in dealing with it. I did want to note that Janet brought up the issue of spyware being used, and that there are, serious limitations in the ability to find accessible reviews of both devices and audio, on autos, so on cars, around spyware and other types of location devices, and that's definitely true. We do have a good amount of content if people want to learn more about spyware on our website, and encourage people to explore that a little bit. Moving forward, I want to hear a little bit about the sharing of skills. So are there skills that you think anyone, both those in chat as well as Julie or Carol, are there skills that you think that would help other judges better respond to tech abuse? Or are there skills that you yourself use that have been really useful that you could share?
I've said this a couple times already on this webinar, but I think that we already, as judicial officers, we already have a lot of the skills that we need. We already have the ability to understand how to admit evidence and to do it in ways that make sure that the evidence that the court needs to hear is heard and is appropriately brought into the case. We also have the ability to assess credibility. That's one of the things that we hone as judicial officers. So I think we have those skills. I would just add, in terms of taking a look at the materials that we have presented here today, if you look at the slide, common tech used in domestic violence, and mirror that and match that with the common evidence issues, I think if you put those two pieces together with your own skills that you've already developed as judicial officers, you're going to be able to navigate this in ways that maybe you were a little intimidated by coming into this webinar. I would also note, Kay indicated in the chat, family advocates are a good resource, and I think that they're the ones in your domestic violence shelters, in your state coalitions, in the national network, that really are seeing on some level, they're our first responders in terms of this kind of tech abuse, and that we can gain knowledge skill sets from them in terms of what they're seeing and what is going to help to keep folks and kids safe.
Carolyn, anything you want to add?
Well, I'll just add and that I think being flexible and following up on what Julie said, we already have the skills regarding evidence and evidentiary foundations, and they're really the same for this type of evidence that's being presented. So I think she's really hits the nail on the head that so many of us are intimidated by this type of evidence that comes in, but really the rules are the same, the standards are the same. Most of this evidence meets the authenticity requirement. Much of it's not hearsay, and just becoming familiar with how this fits in, and there's great articles and great resources out there to help us feel more comfortable. And it sure has helped me a lot by just educating myself, and I really do think it's something we all have to do, and it's helped my skill set. Before I studied this a lot, I guess I wasn't crafting orders that really were addressing all the issues, and I think that that's the biggest thing that I can do when I find that this happens is taking the time to craft the orders that will cure the harm as much as possible and have people leaving the courtroom feeling that they had their day in court and they have a remedy for the harm that they suffered.
Great. Thanks, all. I did want to note that Mark had brought up an observation, I think, and I think it's an accurate one, is that there has been a historic prejudice about electronic evidence as potentially less authentic, less likely to be real than some other evidence. I think that is changing. I think people are accepting it more and more. The reality is that any evidence can be modified, including the evidence that's reliable more than anything else. Testimonial evidence, right, can be modified. But there are lots of implications about technology and the usefulness of it, and that evidence is being used all across the country in all levels of the court system. And there are mechanisms to improve reliability that we're hoping that at least some of you all can join us in our upcoming, I'm actually just going to move a little bit forward here. For our cyber violence court training initiative, we are building out a multi-day training to help people think through, to help judges in particular, to deal with the ways that technology is impacting cases and to deal with the evidentiary issues, discovery issues, and the safety issues that arise. And so there's going to be not only a large collection of written resources and materials, but also a training collection that will be both a multi-day and portioned out chunks that can be used throughout the country. So we hope that at least some of you all will have a chance to participate in some of those. I do want to note, as a part of GEN and the Judicial Engagement Network, that we're also talking, the CCI and Wormfeld and others on her team are also working around the country to help people to more effectively, have courts that are ready and prepared to deal with tech issues, not only just around evidence, but around confidentiality and that are necessary for the court system. So there are options out there, and we do hope that that you all will reach out. There are some other resources that you might want to look at here. Without my consent, Cyber Civil Rights Initiative, Cyber Civil Rights Legal Project. Ken L. Gates has a really impressive cyber law and cybersecurity section. There are a variety of different resources out there, and I did want to point at this last one. This admissibility of electronic evidence is a really fantastic chart that was just actually created by a couple of judges that I think might be really useful for you all to look at. So just as some examples of things that, that you might want to go through and look at. Here's all of our contact information, and we would love to speak with you further if you have other questions. We, at least my office does a lot of technical assistance and TA with judges thinking through some of these issues. I know the rest of the team is also to speak with you as well. So I'm going to give Carol and Julie an opportunity to sign off, but I just want to say thank you all so much from me, and I'll pass it over to Carol or Julie.
I would like to say thank you, too. This has been a wonderful opportunity. I want to thank my co-presenters who have helped me learn a lot, and thank you.
And thank you all for your interest in this topic and not being afraid to wade into the world of cyber violence and tech abuse. And I myself am very excited to be part of this project and to rely on the expertise of the folks who are on this call from NCJ, FCJ, and the Safety Net Project and GEN, and I would invite you all to do that as well. Our contact information is on the last slide. I know I speak for the others. Feel free to contact us with any questions, and thank you so much for your time today.